we've had a really overwhelming overwhelming interest for this event. And we're so glad for those that have been able to join us in person and online. My name is Sarah Frey, and I'm a communications contractor with the First Nation of Na-Cho, Nyäk, and I'm really grateful to be here today with our team. Today we'll be talking about Yukon court cases and how they have impacted Yukon mining. So today we have Tasha Manoranjan joining us, Nuri Frame, Chief Hope, Millie Olson, and Lauren Baranek. Before we begin, I would like to ask Chief Hope to start us off in a good way.
Well, good morning, everyone. Thank you for coming. Creator, thank you for bringing us all here today and help guide and watch over us and help us keep our minds open for finding a better way forward and keeping all those who are not here, who don't have a voice here today, in mind. The environment, the animals, and all the people that use the land and have cherished it for millennium. Masicho.
Thank you so much, Chief. So this morning we're going to get started with presentation on court cases and what you need to know. It's going to be about an hour and a half, and then we're going to have a 15-minute Q&A, followed by a quick break. And then we're going to get into an overview of the FNNND Mining Policy that was passed by Chief and Council on June 24th, 2024. And then we'll have a Q&A following after that. This afternoon will be a repeat session. So for those of you thinking you have to dedicate your whole day to it, we really just wanted to make sure that as many people had access to the information that we're sharing today. For those of you joining online, feel free to drop your questions in the chat and we'll be reading them out for the panel here. And these sessions are being recorded and will be released. So stay tuned to our channels for more information on that. And without further ado, take it away, team.
So thank you everyone for coming. Just like yesterday, it's not a formal agenda or anything. We're just going to have some open discussions and then some question and answers. I will hand it over to our team who has been working on our court cases and will provide a summary of those and how we're going to move forward. So I'll hand that over to Nuri Frame. Thank you.
Great. Thank you, Chief. And good morning, everybody. My name is Nuri Frame. I'm the managing partner of a firm called Pape Salter Taille. We're outside legal counsel to the First Nation of Na-Cho, Nyäk. Our firm's been working with FNNND since well before the UFA, since 1983 or 84. And it's a huge point of pride for us to have been able to work with FNNND and other Yukon First Nations, both in the process of moving towards treaty and now in the process of implementing treaty. And I think the sad and hard realization that many of us who work in this space have come to, and certainly that many of the First Nations who are living in this reality have come to, is that reaching treaty wasn't a destination. It was actually when the hard work started. And that as challenging and as the courts have said, and as we'll hear today, as monumental an achievement as the UFA and the Yukon final agreements were, they didn't solve the problem and they didn't finish the work. In fact, they were the starting gun for a huge amount of additional work that needed to be done, and I think as we're going to see today, still needs to be done. And one of the unfortunate lived realities in Yukon up to this point is that many of the most important achievements in terms of treaty implementation, particularly in the context of resource management, resource development, and mining in particular, have not happened at the negotiation table and have not happened through effective intergovernmental processes, but rather have happened in courtrooms. And nobody wins when that's the case, says the lawyer. Nobody wins when these critical questions of treaty relationship, treaty implementation, and land management are being decided adversarially, being decided by judges, often then being decided by courts of appeal, and as we'll hear repeatedly in the Yukon context, by the Supreme Court of Canada in Ottawa. Nobody entered into treaty in the hopes that 9 people in Ottawa would decide how things happen here in the territory and would decide how things happen in the traditional territory of the First Nation of Na-Cho, who we're here with today. And I think our hope by sharing this history of litigation and by sharing our perspectives on what these cases mean and how they signpost the path forward from here, we can, with some goodwill and some luck and a hell of a lot of effort, find a way to see these treaty implementation issues and the promises of the treaty realized intergovernmentally and realized at the negotiation table, not realized in the courtroom, which, and I'm sure there's folks from industry here today and certainly online, it does no good for proponents to be in a situation where their projects are going to be imperiled and risked, if that's the word, by the uncertainty around what treaty implementation is going to mean. And as you'll hear, repeatedly what has happened is when projects have been challenged in Yukon, generally the underlying issue has not been proponent conduct. It has been government conduct, and there certainly are bad proponents. We heard yesterday about Victoria Gold, and it's hard to imagine a worse one. But today we're going to hear about some proponents who I don't think are bad proponents, but they're proponents whose projects were imperiled and ultimately defeated in judicial processes because the underlying treaty promises and treaty pathways that should have de-risked those projects had not been lived up to by public government. And that's a huge failure. And it's a failure to First Nations, it's a failure of reconciliation, but it's a failure to industry, and it's a failure of the treaty. And I think really what NND is hoping to do today is to help point towards a pathway where that isn't what happens in the future. And I think when that happens, both through intergovernmental processes and then, as we'll hear later in the presentation, through the implementation of NND's mining policy, which is, in our view, the pathway to free, prior, informed consent for projects in NND territory, we start to see ways of doing it differently and ways in which actually the treaty's promise of win-win relationships, or maybe win-win-win relationships between public government, Indigenous governments, and industry can start to be realized. So my law partner, Tasha Manoranjan, is going to start us off with some discussion about the treaty framework and about the case law that got us here. And then I'm going to spend a little bit of time talking about 2 recent cases. First one called Na-Cho v. Yukon. There's a few cases called Na-Cho v. Yukon. This one we sort of colloquially call the metallic minerals case. And then another, perhaps even more unfortunately, called Yukon v. Yeseb, which again we colloquially call the Michelle Creek case. And those really speak to mining and land use planning in NND traditional territory. So I'll hand it off to Tasha.
Great, thank you, Nuri. Technical difficulties, sorry. Thank you so much, Jesse. Great. Good morning, everyone. It has been a privilege to work with NND, and I'm really excited to share some of the legal context for NND's work in court and outside of court to advance the rights enshrined in the final agreement. So just to start off with a little bit of background and context for the First Nation of Na-Cho, Nyäk, NND is a self-governing First Nation, and their traditional territory covers over 160,000 square kilometers, which include lands in the Yukon and the Northwest Territories. And NND's traditional territory has been a key focal point for mineral exploration and development in the Yukon. There are over 82,000 placer and quartz claims on the NND traditional territory. And in fact, that number reflects approximately 43% of all quartz mining claims in the Yukon. We heard yesterday about the Eagle Gold disaster, so we don't need to go in detail on that, but of course, everyone is familiar with the June 24th catastrophic failure of the heap leach facility at Victoria Gold's Eagle Gold Mine, which released over 4 million tons of cyanide-laden ore into the heart of the NND traditional territory. So just unpacking what those numbers actually look like, this demonstrates all of the claims that have been staked on the NND traditional territory since 1993, so since NND entered into the final agreement, and it reflects just the sheer scope and scale of mineral activity on the NND traditional territory since signing the final agreement. And we want to look at the final agreement in a bit of detail and talk about what the core overarching promises of NND's treaty include. So first, the promise of sustainable development. Sustainable development is defined in the treaty as beneficial socioeconomic change that does not undermine the ecological and social systems upon which communities and societies are dependent. And this promise is woven throughout the treaty and is meant to guide how the land is used and managed. It's meant to ensure that any development on the NND traditional territory is consistent with that promise of sustainable development, that it will not undermine NND's relationship with the land. The second core overarching promise that we want to highlight is the promise of co-management. The promise that NND would co-manage their traditional territory with public government. And that promise, too, is interwoven throughout the treaty and particularly comes to life in Chapter 11. Chapter 11 of the final agreement promises that NND and public government will undertake a land use planning process that will determine whether, where, and how development can take place on the NND traditional territory. That promise, among others, has not been lived up to. Chapter 12 is also important here. Chapter 12 promises a development assessment process that will ensure, again, that any development on the NND traditional territory is consistent with sustainable development. Again, that promise has not been lived up to. In terms of land use planning, NND and Yukon government signed a memorandum of understanding earlier this year to finally initiate the land use planning process, which is an important step forward. But again, the beginning of a journey, not the end. The land use planning process itself has not begun. Now turning to some of the cases that we wanted to highlight today. The first we wanted to draw on is the Manitoba Métis Federation case that the Supreme Court of Canada held and decided in 2013. This is not a Yukon case. It's obviously a case from Manitoba, but it is important legal context for how treaties are meant to be understood and interpreted and implemented. So we wanted to start here. In this case, the Manitoba Act, which established Manitoba as part of Canada, promised 1.4 million acres of land grants to Métis children. And this promise was that the land grants would be made in the most effectual and equitable manner, recognizing that there was going to be a wave of settlers coming from the east and trying to protect the land that the Métis held in Manitoba. Despite this promise, the Crown significantly delayed its implementation for over a decade, which impacted the interests that the Métis children ultimately received. The Manitoba Métis sought declarations, including that Canada failed to implement the Act in a manner consistent with the honor of the Crown. And the court agreed. The Supreme Court found that Canada had failed to implement this provision, Section 31 of the Manitoba Act, as required by the honor of the Crown, and explained what the honor of the Crown requires in implementing treaty promises and constitutionally protected promises, such as this section in the Manitoba Act. The Supreme Court explained that when the issue is around how to implement a constitutional obligation to an Aboriginal people, the honor of the Crown requires that the Crown take a broad, purposive approach to the interpretation of that promise and act diligently to fulfill it. The court went on to explain that the honor of the Crown demands that promises to Indigenous groups be treated and interpreted generously and consistent with their intended purposes. The court looked to an earlier case, Haida Nation, in which the Supreme Court found that the Crown must consult with Indigenous peoples when contemplating conduct that may adversely affect their rights and interests, and explained that that promise and that duty to consult must apply to asserted and yet unproven rights in land. And the court found that when the distant goal of proof is finally reached, proof of Aboriginal title in the Haida case, the Aboriginal peoples may find their land and resources changed and denuded. This is not reconciliation, nor is it honorable. And this language, I think, is particularly applicable to the NND context in the sense that land use planning has been delayed for so many decades, and NND's lands have been changed and denuded, to use the court's language in the Haida case, as a result of this delay. So in the Manitoba Métis case, the Supreme Court found that the Crown must consider the purpose behind treaty promises and actively work to fulfill them. The court went on to explain that an honorable interpretation of an obligation cannot be a legalistic one that divorces the words from their purpose. The honor of the Crown demands that constitutional obligations to Aboriginal peoples be given a broad and purposive interpretation. This means that the Crown must actively work to ensure that its obligations are fulfilled. And to fulfill this duty, the court said, Crown servants must seek to perform the obligation in a way that pursues the purpose behind the promise. The Aboriginal group must not be left with an empty shell of a treaty promise. The court went on to explain that violations of the honor of the Crown do not require bad faith. It doesn't require government misconduct. The court explained that in taking over 10 years to resolve the land grants that the Métis children were promised, the Crown acted with persistent inattention and failed to act diligently to achieve the purposes of the grant. And that was sufficient to find that they had violated the honor of the Crown. The Supreme Court found that the government had acted with repeated mistakes and inaction that persisted for more than a decade. A government sincerely intent on fulfilling the duty that its honor demanded could and should have done better. And I think that language holds true for NND's treaty promises as well. Now turning to Yukon case law, this case was brought by Little Salmon Carmacks First Nation. It's the Beckman case, another case that was heard before the Supreme Court of Canada. And in this case, Little Salmon applied for judicial review of a decision by Yukon government to approve the grant of 65 acres of land to a private citizen for agricultural purposes. The land grant included land covered by a trap line by a Little Salmon citizen, Johnny Sam. Little Salmon argued that Yukon had failed to comply with its duty to consult with respect to this particular land grant. Yukon government's response was that no consultation was required because the final agreement does not contain a provision requiring consultation during the land grant approval process. Yukon government officials said that they had meetings and discussions with Little Salmon about this application, quote, only as a courtesy. So Yukon government's position was that their engagement with Little Salmon about this land grant was simply a courtesy. The court noted that consultation was referenced over 60 times in the final agreement, but not specifically with respect to land grants. The court found, however, that it was obvious that land grants might adversely affect Little Salmon's traditional activities, and thus the Crown's duty to consult was obviously engaged. Yukon was required to consult Little Salmon to determine the nature and the extent of such adverse effects of this land grant on their rights. The Supreme Court said that the Crown cannot attempt to contract out of its duty to honorable dealing with Indigenous peoples. That duty applies independently of the intention of the parties as expressed or implied in the treaty itself. Consultation is required to help manage the important ongoing relationship between the Crown and Little Salmon in a way that upholds the honor of the Crown and promotes the objective of reconciliation. The Supreme Court further held that the treaty will not accomplish its purpose if it is interpreted by territorial officials in an ungenerous manner or as if it were an everyday commercial contract. The treaty is as much about building relationships as it is about the settlement of ancient grievances. The future is more important than the past. The court also explained that the honor of the Crown is a constitutional principle that is always at stake in its dealings with Aboriginal peoples. In other words, consultation is not merely a courtesy. Now turning to mining-specific cases. The Western Copper case was a case brought by Western Copper to appeal the Yukon Water Board's decision denying its application for a water license for a proposed copper heap leach mine, the Carmax Copper Project. The Water Board had denied this application due to environmental risks associated with the heap leach method that Western Copper was proposing. Western Copper claimed that the Water Board's denial breached its obligation to implement the decision document that YG had already issued that accepted YESAB's recommendation to approve the project. And Western Copper claimed that the Water Board had exceeded its jurisdiction by purporting to regulate mining facilities contrary to the court's mining license authorization that YG had already issued. The respondents, which included the Water Board, YG, Little Salmon Carmax First Nation, Selkirk First Nation, and Yukon Conservation Society, maintained that the assessment and regulatory processes are distinct, and the Water Board has the discretion to refuse a license unfettered by a decision document recommending the project be approved. And that EMR and the Water Board have overlapping rather than conflicting jurisdiction over mining operations. The court agreed with the First Nations, the Water Board, and Yukon on both issues. The court found that the Water Board expressly disagreed with YESAB's finding that certain aspects of the heap leach technology have proven to be viable, and that was well within the Water Board's jurisdiction to do so. The court looked at both the Waters Act as well as the final agreements and found that the board has wide discretion and can refuse to issue a license. The court also noted that Western Copper's suggestion that the Water Board leave the heap leach process exclusively to Yukon government's Chief of Mining Land Use would be an abdication of the Water Board's duty to exercise its jurisdiction over water, where the process of degradation or alteration begins. The court noted that the Water Board has a crucial role to play in ensuring that water effluent from the heap will meet acceptable discharge and acceptable discharge criteria, and that Western Copper, not Yukon or Yukon citizens, and I would add, or First Nations, bear the environmental and financial liability for the water used in the heap leach process. So the court emphasized that the Water Board was correct to consider whether or not the heap leach process being proposed was actually responsible. And it was entirely within the Water Board's jurisdiction to determine that it was not, and would not ensure that the proponent was the one who would bear the environmental and financial liability if something went wrong. The court found that mining is indeed subject to overlapping regulatory oversight, and the Water Board can, of course, regulate aspects of mining operations that are subject to a quartz mining license, where those aspects involve the use and treatment of water. The next case we want to turn to is from Liard First Nation against Yukon government and Selvin Chihang Mining. In this case, Liard First Nation applied for an order to quash, suspend, or stay a decision document from Yukon government recommending that the Selvin Chihang project be allowed to proceed with its proposed quartz mining exploration activities. Liard First Nation argued, among other things, that Yukon government had breached its duty to consult the First Nation. The court relied on the earlier Supreme Court case Haida Nation and noted that what's required by the duty to consult falls on a spectrum, and where the right is strong and potential infringement of that right is of a high significance, then deep consultation aimed at finding a satisfactory interim solution may be required. The court also noted that the duty to accommodate may require consultation and negotiation to avoid irreparable harm or to minimize the effect of infringement. The court found that the Selvin project, which was not proposed to be an operating mine, still had the potential for significant negative impacts on Liard First Nation and their rights. Thus, Liard First Nation was entitled to consultation significantly deeper than the minimum and accommodation where possible. The court found that that duty was met in this instance. The court noted, however, without making specific findings about the timelines for this assessment and review, that the timeline for environmental assessment of projects and the funding available for First Nations meaningful participation in those assessments must be considered from time to time based on the size and frequency of large projects that First Nations are asked to consult on, such as the Selvin project. The court noted that it will be a challenge for First Nations to participate in these assessments when the development of mining claims is proceeding at a fast pace. It is notable that the application for the Selvin project had to be withdrawn and refiled in order to ensure that the assessment process was meaningful for the First Nation. And I draw attention to that language because the amount and the scope and scale of projects on which First Nations, such as the First Nation of Na-Cho, is asked to consult on is so considerable. Looking at the map that we showed earlier on, you get a sense of the scale of activity that's being proposed on the FNNND traditional territory. And the court has already offered guidance on the need to ensure that the timeline for these assessments of these projects must be meaningful. The next case we wanted to look at is Ross River Dawna Council versus Yukon. In this case, Ross River sought declarations that Yukon government has a duty to consult Ross River prior to recording mineral claims in lands in which they claim Aboriginal rights and title, and that Yukon government had breached this duty, and that future recorded claims which breach this duty are void. Ross River argued that a duty to consult arises before recording mineral staking claims on their traditional territory because Yukon government is aware of Ross River's Aboriginal rights and title claims, and that Yukon government's recording of a mineral claim amounts to Crown conduct. And this conduct undermines Aboriginal title by transferring mineral rights to claim holders
and allows exploration activity that may seriously impede the enjoyment of Aboriginal rights. Ross River argued successfully that the open entry system that existed at the time, under which there was no notice or consultation with First Nations, breaches this duty to consult. Yukon government challenged the recording of a claim as Crown conduct, arguing that the recording of a claim is not contemplated Crown conduct because the Quartz Mining Act does not give the recorder any discretion over the recording of the claim. Yukon government argued that there was no duty to consult. The court noted that while Class 1 exploration programs are less intensive and cover smaller areas than Class 2, 3, and 4 programs, they can still have, quote, a substantial impact on the land. And the court found that Class 1 exploration programs may, quote, seriously impede or prevent the enjoyment of some Aboriginal rights in more than a transient or trivial manner. And thus the duty to consult attaches. The court also explained that though there is a long tradition of acquiring mineral claims by staking, and this system is important both historically and economically to the Yukon, but it must be modified in order for the Crown to act in accordance with its constitutional duties. The court found Yukon does have a duty to consult prior to recording staking claims, and the Yukon's alleged lack of discretion in the recording of the claims did not absolve Yukon government from ensuring that its contemplated conduct, here the recording of claims, must comply with the duty to consult. Further, the Crown noted that the Quartz Mining Act does indeed provide Yukon government with discretion to prohibit quartz mining claims on specified lands. The court also noted that statutory regimes that, quote, do not allow for consultation and fail to provide any other equally effective means to acknowledge and accommodate Aboriginal claims are defective and cannot be allowed to subsist. The court also noted that notifying Ross River about recorded claims does not discharge the duty to consult. The court said that the level of consultation required cannot be determined at the outset, but the regime must allow Yukon to consult meaningfully with Ross River and, where required, accommodate Ross River's concern before its claimed rights or title are adversely affected. The next case is a case brought by White River First Nation. White River applied to quash a decision by Yukon government allowing a Class 3 quartz mining exploration project to proceed to regulatory approval, contrary to the YESAB designated office's recommendation. The designated office made the rare recommendation that a project not proceed because of unmitigable impacts to an endangered caribou herd, the Chisana caribou herd, and unmitigable impacts on traditional land use and the culture of White River First Nation. The Chisana caribou herd were traditionally harvested by White River First Nation, but were subject to a voluntary hunting ban that White River imposed on themselves since 1994 because of a dramatic decline in this herd. EMR agreed that there were concerns about this particular caribou herd, but concluded that these concerns were exaggerated because telemetry data demonstrated, according to EMR, that the herd was stable. Yukon government held a meeting with White River to discuss YESAB's recommendation and the evaluation report, but Yukon did not disclose the basis on which it intended to reject that YESAB recommendation that the project not proceed. White River argued that Yukon had breached its duty to consult White River before issuing its decision document allowing the project to proceed to regulatory approval. Yukon's response was that it had discharged their duty to consult because it held that meeting with White River to talk about the evaluation report before issuing its decision document. The court quoted from Justin Binney in the earlier Beckman versus Little Salmon case and noted that a decision maker who proceeds on the basis of inadequate consultation errs in law. The court concluded that Yukon government had a, quote, stringent duty to consult White River First Nation, and that it had breached this duty by failing to provide White River with an opportunity to respond to its basis for rejecting the recommendation from YESAB. The court noted that, yes, Yukon government and White River had met to talk about this project, but Yukon never disclosed its concern about the telemetry data, suggesting that the caribou population was stable. Justice Vail said that this meeting amounted to, quote, tell us what you think about the evaluation report, but we will not give you any idea where we have problems with it. The court found that this was not fair nor meaningful in terms of consultation. It was simply, quote, an opportunity to blow off steam rather than meaningful exploration of the facts and discussion required about appropriate accommodation. The court found that Yukon government should have given White River the opportunity to give an opinion on the data being relied on and to reject the recommendation that the project not proceed. The court found that this is about the Yukon giving the First Nation a say on the ultimate policy decisions that Yukon makes. The court found that Yukon had breached the duty to consult, and remedying this breach required quashing the decision document that this project proceed. The next case we want to look at is not mining specific, but it's one of the core cases that explain what Chapter 11 requires. So it's a case brought by FNNND, Yukon First Nation, and environmental NGOs relating to the Peel Land Use Plan. So some context here, in 2004, the Peel Watershed Planning Commission was established to develop a land use plan for the Peel watershed. In 2009, after years of research and consultation, the Planning Commission submitted its recommended land use plan. In 2011, the Commission released its final recommended plan. Yukon government then proposed and adopted a final plan that made substantial changes to the plan that had been recommended by the Planning Commission, focused on increasing access to and development of the region. So FNNND, TH, Wintagwitchin, and others applied for orders to quash Yukon government's decision to approve its Peel Watershed Land Use Plan. The First Nations and the environmental NGOs claimed that Yukon's adoption of its final plan exceeded its authority under Chapter 11 of the final agreements to modify a final recommended plan. And that was authority that they argued were restricted to the modifications that Yukon had proposed to the initial recommended plan. As a remedy, the First Nations argued that the process should return to this stage after the Planning Commission issued its final recommended plan, at which point the parties could accept, modify, or reject the plan after further consultation. At the lower courts, Yukon argued that its ability to modify the final recommended plan that the Planning Commission had proposed was unconstrained. At the Supreme Court, however, Yukon accepted that its ability to modify the land use plan did have limits, and that it breached those limits in adopting its final plan. Yukon, however, argued that the process should return to the stage after the Commission issued its initial recommended plan, where Yukon would have had wider license to propose modifications. The court agreed that Yukon government had exceeded its authority to modify the final recommended plan under Chapter 11, and clarified that this authority is limited to modifications based on those that Yukon had proposed earlier in the process, or modifications that respond to changing circumstances. The Supreme Court found that in all cases, Yukon can only depart from positions it has taken in the past, quote, in good faith and in accordance with the honor of the Crown. The Supreme Court, like the trial judge and the Court of Appeal before it, noted that Yukon's conduct was not becoming of the honor of the Crown. The Supreme Court in this case considered the appropriate role of courts in the implementation of modern treaties. The court found that modern treaties are intended to, quote, renew the relationship between Indigenous peoples and the Crown to one of equal partnership. The Supreme Court found that in resolving disputes from modern treaties, courts should generally leave space for the parties to govern together, but courts must play a critical role in safeguarding the rights enshrined in modern treaties, and adequate scrutiny of Crown conduct is necessary to ensure constitutional compliance. The court further considered Chapter 11 in light of modern treaty implementation principles, which requires paying close attention to treaty terms. The court found that interpreting the provision at issue in light of the treaty text as a whole and the treaty's objectives is required. The Supreme Court further noted the language from the earlier Beckman case that a modern treaty will not accomplish its purpose of fostering positive long-term relationships between Indigenous peoples and the Crown if it is interpreted by territorial officials in an ungenerous manner or as if it were an everyday commercial contract. The Supreme Court considered the context and objectives of Chapter 11 of the final agreements, finding that it establishes a comprehensive process for how the territorial and First Nations governments will collectively govern settlement and non-settlement lands. The court returned the parties to the stage after the commission issued its final recommended plan. And Yukon's approval of the plan was quashed. And the last case that I will touch on before turning it back to Nuri is another case brought by Ross River Dene Council against the Yukon. In this case, Ross River, on behalf of the entire Kaska Nation, appealed a decision from Yukon Supreme Court, which had upheld a decision document from Yukon government and Canada, allowing BMC's proposed open pit and underground copper, lead, and zinc mine to proceed on the Kudzakaya lands on KFN's traditional territory. The project was proposed in, quote, a core area of Kaska traditional territory, which was significant for cultural and environmental reasons, including vital wildlife habitats, sacred sites, and traditional hunting and gathering areas. This project was proposed within the range of the Finlayson caribou herd, which was a species of special concern and had long been relied on as a food source by the Kaska. The project was also proposed close to 3 abandoned, failed mining projects, Wolverine, Faro, and Ketzla River. This was the context for the Kaska's concerns about this project on their lands. The lower court had concluded that the Crown met its duty to consult the Kaska, except with respect to Yukon government's treatment of one document in particular. The lower court judge had ordered limited additional consultation to address this failure in consultation and ordered that a new decision document be issued shortly after. The Kaska appealed the lower court decision that the rest of the Crown's consultation was adequate, particularly on the issue of the economic feasibility of the project. The Kaska were concerned that, like previous mining projects in the region and in the Yukon, the mine would fail and the burden of reclamation would fall to taxpayers. As part of its submissions to YESAB, Liard First Nation provided an expert report that flagged problems with BMC's financial models and projections, noting that it was unclear how BMC planned to pay for its post-production activities, such as closure and reclamation. The court found the Kaska were asking a broader question. If the mine economics are too uncertain and high risk, and if the mine is going to create significant adverse effects, why approve the project in the first place? Is it even worth it? The Court of Appeal found that the decision bodies, Yukon and Canada in this instance, refused to engage with the Kaska on this question of economic feasibility of the mine. They just deferred it to what might occur during the regulatory phase after the decision bodies had already approved the project. The court concluded that the decision bodies unreasonably denied the Casca the opportunity to be consulted on the economic feasibility issue. The court concluded that under YESA and the decision body's common law duty to consult, the Casca, quote, ought to have been permitted a say on what it felt were deficiencies or problems with BMC's projections related to the economic feasibility of the project. It ought to have been listened to and had its views considered if it had concerns about whether the project was feasible or too high risk to justify the adverse effects. And the Court of Appeal concluded that it was unreasonable for the decision bodies not to consider economic feasibility of the project with meaningful dialogue with the Casca before making the decision to approve the project. So here as well, the court set aside the decision document and remitted the matter to decision bodies to allow for greater consultation with the Casca.
And I'll turn it to Nuri.
Great, thanks, Tasha. Let me see if I can get this up. So, and I think that's a really helpful overview for all of us of the unfortunately long line of case law we've seen develop in the Yukon, so frequently dealing with mining, so frequently dealing with failures of the assessment process, failures of the consultation process, failures of the intergovernmental process to lead to good outcomes, invariably resulting in litigation and so often resulting in projects, often projects where vast amounts of money have been spent not going forward. I think it's also telling how many of those cases are from the central Yukon, right? We see cases from Na-Cho, and we'll talk about more of those now. We see multiple cases from Ross River. We see multiple cases from Little Salmon Carmacks First Nation. I see we have representatives of the LSC Lands Department here today, and I suspect if we asked them, they wouldn't say, no, everything's fine now. So it's worked itself out. Those cases were anomalies. The reality is those cases weren't anomalies. And the cases that I'm going to talk about now aren't anomalies. And that's, I think, reflective of and instructive of the fundamental failure that NND has been trying so hard to bring forward in its engagement with government and in its engagement to industry, saying we need to do things not a little bit differently, but fundamentally differently if we're going to prevent this march to the courtroom from continuing, which is, again, even for the lawyers, it's not what we want to be doing, right? The purpose and the promise of self-government and the treaties was that nations would be able to spend their time and their money and their resources on the things that were important to them and their people. They were not supposed to be spending their time and their money and their resources responding to government priorities and then fighting those same governments in court when their voices weren't heard. That's not what self-government was supposed to mean. And Section 35, similarly, was not supposed to be a constitutional ticket to sue. It was supposed to be a process by which rights would be proactively and meaningfully recognized and affirmed by government so that this really tragic dynamic of reconciliation by way of litigation would fall by the wayside. And that is not what we've seen happen in Yukon and certainly in central Yukon up to this point. So I'd like to talk a little bit about two recent cases, particularly one recent case, and then a little bit about the second most recent case, to really talk about where things are pretty much today. These are both cases from the last few years, both cases that involved the First Nation of Na-Cho, both cases that our firm worked on. I worked on both. Tasha and I worked together on the second, and I think really provide good insights into the problems that we so urgently need to be focusing on right now. So the first case, which again is captioned Na-Cho v. Yukon, not the first, as I said, we call the metallic minerals case. It's a judicial review, so it's a challenge to a government decision brought by the First Nation of Na-Cho with respect to the authorization of a Class 3-4 advanced exploration project that was proposed by a junior mining company called Metallic Minerals in the heart of the unplanned portion of NND traditional territory within the Beaver River watershed. And I want to say at the outset, although we're going to call the case Metallic Minerals is not the villain in this story. And I think it's important for me to acknowledge that from the beginning, as a proponent, they were very clear that if this was a project NND was so strongly opposed to, they were not looking to proceed with it over that kind of objection. And although this case was litigated for several years, Metallic Minerals and their lawyers, and they had lawyers, took no position, didn't come to court, or if they did come to court, they came to court purely to observe and made no arguments to oppose what NND was doing. And I think it's important to acknowledge that and to acknowledge that they, as a proponent, recognized that this was not really a fight about them, and that they and their project were, and I use this term sort of guardedly, almost collateral damage in a broken treaty relationship and a broken treaty implementation relationship. And that's really, I think, reflective of why we need to do this better. Because I think what we've seen is a really misguided sense from government that prioritizing approvals for mineral development projects over First Nation objections in the absence of land use plans is helping industry, and it's not. It's hurting industry. And I think Metallic Minerals and this project is a perfect example of that. And Metallic Minerals knew that. They knew that trying to move forward with a mining project in the 21st century in Canada, in the age of UNDRIP, in the age of the final agreements, over strident and vocal First Nation opposition was not only stupid, it was impossible. And they didn't try. And unfortunately, government doesn't seem to have recognized that self-evident truth. And instead, we see this persistent tendency to minimize, to marginalize, to sideline First Nation concerns in order to authorize projects. And the result is not, and so the mining industry flourishes and the proponents benefit. Instead, the opposite happens. And again, I keep pounding the table on that because I think it's really important that we be conscious of the fact that this is not about an adversarial or an oppositional relationship between First Nations and the mineral development industry. This is about failures to implement treaties, as Tasha talked about, failures to live up to the purpose behind the promise. And First Nations in Yukon, certainly the First Nation of Na-Cho, Nyäk, being left to feel that it has been left with, again, to court, the Supreme Court of Canada, an empty shell of a treaty promise. And that's the dynamic which is creating the problems. And that's the issue that has to be fixed. So this case, as I said, involved an advanced exploration project in the Beaver River watershed. This is an area where there is no land use plan under Chapter 11 of the final agreements or otherwise. But it is an area in which there was an underway, and still is to this day, an underway land use planning process. And I won't get into sort of the gory details of how that happened, but in connection with a desire from a different proponent, at that point it was ATAC Resources, their interests have since been acquired by another company, to build an all-season road in this part of NND traditional territory. An intergovernmental agreement had been reached by NND and Yukon government back in 2018 to undertake regional land use planning process in this particular part of the NND territory, basically saying, somebody wants to build an all-season road, we get that that's a big deal, we're going to hold off on giving final approval to do that until we can complete a regional land use plan or sub-regional land use plan for the immediate area of the road and the project. So I think the big takeaway here is it's a land use planning process which has started but not finished. And in that context, Metallic Minerals proposes an advanced exploration project. So the project goes through YESIB, as these projects do. YESIB identifies that this is a project that will have significant adverse effects and sends its evaluation report on to Yukon government. Yukon government then engages in what we'll politely call consultation, though I think if I was, for those who were here yesterday, Bill Slater, one of NND's technical reports, and Stephen, you and I were talking about this, put up his sort of summary of what Yukon government had done and then put a big fail in red letters on it. I unfortunately am not that well prepared, and I didn't bring a big red fail stamp, but I think what we can, to jump to the end, the conclusion was the consultation that happened is a big red fail. So consultation, again, in scare quotes, occurred between Yukon government and the First Nation of Na-Cho about this proposed project in this area where a land use planning process had commenced but not finished, and in an area where there was no interim protection of the land while that process was underway. And that process went on for many months, and there was engagement and discussion about environmental impacts, how to protect water bodies, how to protect moose, how to protect sheep, how to otherwise mitigate purely environmental impacts. But NND persistently through that process said consultation isn't just about mitigating environmental impacts. In fact, consultation isn't even principally about mitigating environmental impacts. Consultation is about identifying, discussing, and accommodating adverse impacts to treaty rights. And this is a hugely important distinction. The purpose of consultation is not to talk about environmental issues. Environmental issues are relevant because there's often a close nexus between impacts on the environment and impacts on Indigenous rights. If you kill all the moose, then obviously that has an adverse impact on moose harvesting. If you dump cyanide into the water where people harvest grayling, that obviously has an impact on people's ability to harvest. If you build a hydroelectric facility and destroy the ability of Chinook salmon to travel upstream and spawn, that obviously has an impact on the fishery. But the salient point that, again, I want to emphasize is the purpose of the consultation is to talk about the right and to talk about the impact on the right. And in the context of this project, NND persistently said, yes, we've got to talk about the adverse impacts on the environment, but we also have to talk about the adverse impacts of this project on our rights more generally, and particularly the adverse impacts of this project on our right to a land use plan. And as we've seen, and Tasha talked about the Beckman case, which made this point, Little Salmon's case, and about the Peel case that made this point, Na-Cho case, one of the central purposes and promises in the final agreements is that First Nations in Yukon will be participants in decisions about how lands across their traditional territory are managed and governed. And that one of the principal mechanisms by which that is done is land use planning. Right? And the courts have recognized that repeatedly. They recognized that in 2010 in Beckman. They recognized that in, what is the appeal case, 2017 appeal case. They recognized it again in this case, and again in the Court of Appeal in this case, and they're going to recognize it next time as well. And so NND persistently asked Yukon to consult about what approving this project would mean to land use planning. And the basic premise of that question was, if you've already developed the land, how can we plan for it? If you've already approved projects across the territory that fundamentally change the land from the way it was when the treaty was signed 30 years ago, how can we meaningfully plan? That's backwards. Fundamentally, we need to plan first and develop second. Because if we develop first and plan second, then we're not planning. We're just saying sorry. There's nothing left to plan. I guess everything's a go because there are no preserved, pristine portions of your territory left. And this was the conversation NND kept asking to have during consultation. And it asked for this at the officials level, and it asked for this at the ministerial level, and it asked for this in correspondence with the Premier. It kept saying, nobody is talking to us about our rights. Nobody is talking to us about what approving this project will mean to our right to land use plan and our right to participate in the management of lands across our territory. And the response from Yukon government was the same boilerplate, literally 15 letters with the same boilerplate, cut and pasted every single time. Chapter 11 doesn't guarantee you a right to land use plan and doesn't give you a veto over projects, essentially. And we're not saying it does. We're saying we got to talk about this and figure out how to deal with it. And Yukon government's internal correspondence, which was produced during the litigation, essentially said, we don't even understand what they're talking about. Maybe they're testing us. That's a quote from inside the department. Complete puzzlement that a First Nation would want to talk about its treaty rights as part of consultation with its treaty partner. In addition, NND said, this is a really big deal. You need to hear from our citizens. They are going to be deeply impacted by this project. And so you can't just consult with the lands department, you need to consult with citizens. And the response from Yukon government was, talking to your citizens isn't feasible. I guess the drive from Whitehorse to Mayo was just overwhelming. And so talking to your citizens is not feasible. We're just gonna talk to the lands department because I think the implication is that's way easier for us. And so after months of correspondence at every level, from former Chief Mervyn to, I guess at that point in time, Minister Pillai, to Premier Silver, and to basically everybody else under the sun, the project was approved. And Gold Star, if anyone can guess what happened next, which is NND filed an application for a judicial review almost immediately in Yukon Supreme Court. And the essence of the challenge that NND brought was twofold. One part of the challenge was that this project should not have been approved because consultation had failed for all of the reasons I've just outlined. That there had been a complete failure to not only accommodate NND's treaty rights, but to even talk about them. NND couldn't even start the conversation around what this project would mean to its treaty rights, to land use planning, and to participation in the management of lands in its traditional territory. So consultation was sort of one half of the case. The other half of the case, and this goes to, I think, some of the themes and principles that Tasha so effectively fleshed out from the history of case law that got us here, and particularly the Manitoba Métis case, which is why we talked about it, because we didn't just start with Manitoba script because we think it's fun to talk about Manitoba script as part of a presentation about Yukon case law, but rather it's because those principles around the honor of the crown that were fleshed out so effectively by former Chief Justice McLaughlin in the MMF case really provide the analytical lens through which you need to understand what government's obligations are in the treaty context. And I think it's pretty clear those obligations are not to sit back and see if the First Nation raises a complaint. And they're not to keep their eyes closed and their hands clasped and do nothing, but rather they are affirmative, proactive obligations that fall on public government to actually take steps to advance the purpose of the treaty, right? To act in accordance with the intended purpose of the treaty, right? So treaty partnership is not a sign the agreement and then walk away and figure the First Nation will sue you if you do something wrong. Although that appears to be how it's interpreted, but rather treaty relationships are about both parties proactively and purposively understanding the treaty, understanding what it requires, and taking steps to advance it. That's what the treaty is. And I'm gonna take a short digression. This is why I don't have stuff written on slides, because I take a lot of short digressions and it ends up revealing that I'm just making it up. So there's my former colleague from the firm Aldridge and Rosling, Jim Aldridge, whose firm were counsel to NND and others in the Peel case, and Jim passed away last year. But he gave testimony at the Royal Commission for Aboriginal Peoples, RCAP, a number of years ago. And he described the difference in the way First Nations and public government think about modern treaties. And I think it's a really, really good metaphor. I know Jim eventually wished people would keep bringing it up. But sadly, I think it remains really vital here in Yukon as a reflection of what's going wrong. And he said, First Nations understand treaties as marriage contracts. And when you get married, you're basically committing to be in it together for the long term. You don't plan everything out. You don't know who's going to do the dishes on Tuesday and who's going to do the dishes on Thursday. You don't know if you're going to go out for dinner on Friday or maybe you're going to watch a movie on Saturday. You figure it out. You figure it out collaboratively and thoughtfully, and as all of us who are married know, sometimes with some difficulty, how we're going to make this relationship work in a continuing way. And you do it by listening, and you do it by sometimes being selfless and sometimes being a bit selfish, and finding out how you can keep this relationship effective and growing and meaningful, hopefully forever. So First Nations perceive modern treaties as marriage contracts, and public government perceives them as divorce agreements. Right? We're going to divvy up the stuff. You're going to get this. I'm going to get that. We're going to spell out exactly. You get the kids every second Tuesday and every fourth Thursday and weekends in the summer. And I've got to pay you exactly this much money for exactly this long, and I never got to talk to you again. And that fundamental misunderstanding or misalignment between whether or not treaties are marriages or divorces continues to infect the process of treaty implementation here in Yukon, at least in my view. And again, I'm sure there are folks in the room or online who might take a different view, but I've been doing this for quite a while, and that seems to be, sadly, a very effective reflection of where we are still to this day. And so that's the end of the digression. So the case, on one hand, focused on consultation, and on the other hand, focused on the other duties flowing from the honor of the Crown, particularly Yukon's affirmative obligation to act in accordance with the intended purposes of the treaty, and its affirmative obligation to diligently implement the provisions of the treaty. So the case was filed in, as I recall, March of 2021. Yukon government didn't take it well. Yukon government moved quite quickly to have the majority of the case struck. They argued that these issues weren't appropriate for judicial review. Maybe we could have a case about consultation, but all this other stuff about honor of the Crown and diligent implementation and intended purposes, my God, this was not an appropriate thing to do. All of this should be thrown out. And the case should move forward at most as a very narrow consultation case. Probably from my tone, you can gather that that motion was unsuccessful. The Supreme Court of Yukon, Chief Justice Duncan, disagreed with Yukon's submission, agreed with NND's position that these questions of the honor of the Crown and of the Crown's obligations, not just in consultation, but also as a treaty partner in terms of diligent implementation and acting in accordance with the intended purposes of the treaty, were absolutely appropriate because they went to the core question of whether or not the decision to approve this project in these circumstances was a reasonable thing to do. And that's the magic word from judicial review case law for anybody who's a lawyer knows, was the decision reasonable? So the case moved forward. Supporting affidavits were filed by the parties. And lo and behold, Yukon moved to strike again, moved to strike every single word of affidavit evidence that NND filed. Affidavit from the director of the Lands Department and affidavits from NND Elder and Treaty Chief Negotiator Albert Peter. And the reasons to strike were myriad. It was irrelevant, it was unnecessary. Albert's reliance on traditional knowledge was improper hearsay, which was a first for me. Actually moving to strike the sentence, I make this affidavit for purpose of this litigation and no other purpose, they moved to strike. I think because nobody read them, they just listed all the paragraph numbers and said, let's strike them all, which for lawyers in the room, read the paragraphs before you list them in your motion to strike. So there was an effort to strike out every bit of evidence, evidence about why the treaty was made, what was intended, what Albert, as the negotiator, had done working with his citizens, working with his elders, working with former Chief Robert Hager during the treaty-making process, and then the work that the Lands Department had done in engaging with this project and what this project meant, both specifically and more broadly. And again, probably my tone is clear, that motion was again entirely unsuccessful. And the court acknowledged and accepted and relied on all of that evidence. And as you can probably guess from the fact that I'm here, because lawyers rarely get onto a dais to talk about cases they lose, the case was successful at first instance before Chief Justice Duncan of the Yukon Supreme Court. The Chief Justice adopted FNND's submissions and concluded that yes, this case was a failure of consultation. Yukon's decision to approve this project in these circumstances was unreasonable and unconstitutional. That it was not reasonable to have refused to consult about FNND's treaty right to land use planning, and it was not reasonable to have refused to consult about how the treaty promise that guaranteed FNND meaningful participation in the management of lands and resources of its treaty territory would be met was not reasonable. Yukon government had suggested that there was no treaty right to land use planning, there was no treaty rights in Chapter 11, that in fact the vast majority of the chapters of the final agreement had no treaty rights in them, which was not a successful argument. The court was, even in its tone, but I would say adamant, that Chapter 11 absolutely contains treaty rights, and they are not just process rights. They are not just rights to a land use planning process someday, one day, maybe if public government decides to allow it. But rather, these are core features of the treaty relationship, core features of the deal that was made, and they need to be honored, and they need to be honored now. Again, court was a little more temperate in its tone than I'm being today. So the court was clear that the duty to consult had been breached. It was clear that the arbitrary and unilateral decision not to consult with citizens because it wasn't quote unquote feasible to make the drive up the road to Mayo was not reasonable. Didn't mean that in every case there needs to be consultation with citizens, but certainly meant that government couldn't dismiss the request out of hand as it had done here. But really importantly, the court also determined that Yukon government's decision was a breach of the duty to act in accordance with the intended purpose of the treaty, which is one of the duties flowing from the honor of the Crown, the Supreme Court of Canada, articulated in the MMF case. And this was, I believe, the first case in Canada to have found an express breach of that duty flowing from the honor of the Crown. And it was, I think, a huge vindication of what FNND had been saying for 30 years, which is that you just can't sit back and let land use planning not happen. You can't just sit back and let the treaty promise of meaningful participation in resource management development decisions go ignored and keep stamping yes, yes, yes on every mining authorization that hits your desk and think you're doing what the treaty required you to do. You're not. And that, again, court's language a little more temperate than mine, but that was the fundamental conclusion of Chief Justice Duncan. Probably no surprise, Yukon government appealed. That appeal was heard by the Yukon Supreme Court, or sorry, the Yukon Court of Appeal in, as I recall, November 2024. It was really cold that November, much warmer this November. And so it was a 3-judge panel of the Yukon Court of Appeal who heard the appeal. And to make a long story short, because I know we do have a lot of conversation we want to have about the mining policy, and I think actually the mining policy is a more exciting thing to hear about than FNND's need to keep fighting to have its treaty rights recognized. I think it's more exciting to hear about how it's in fact taking its own proactive steps to recognize those treaty rights in the failure of government to do so. But Yukon Court of Appeal affirmed the decision of Chief Justice Duncan. They affirmed that this was a breach of the duty to consult. They affirmed that Chapter 11 absolutely has treaty rights in it, and no, those are not just vague, inchoate, amorphous process rights that may accrue in the future. That is a meaningful, direct, immediate right to participation in the management of lands and resources across the territory right now. They confirmed that Yukon government had not acted in accordance with the intended purposes of the treaty. And they confirmed a really important finding, or holding, I suppose, from Chief Justice Duncan, which is that approving projects in areas of the traditional territory that are not yet subject to a land use plan may, in and of itself, breach the treaty rights in Chapter 11. And I want us just to take a second and think about that, because for everybody in industry who's in the room and online, that's a really important thing to keep in mind. That the court has recognized, contrary to Yukon submissions, that of course approving projects in areas where there is no land use plan changes the ability of the First Nation and its public government partners to land use plan in the future. Of course, taking up projects or approving projects before a plan's in place or while a planning process is underway risks undermining the future planning process. And it seems self-evident to me, it appears not to have been self-evident to Yukon, that if you say, we're going to decide what to do with this stuff, and then Tasha picks up half of it and lights it on fire, our ability to decide what to do with this has been materially changed by the fact that half of it's now gone. And similarly, the ability to decide what lands will be protected, what lands will be available for development is fundamentally changed if all of the land or much of the land is already disturbed before those kinds of decisions around what we should do are made. And so that holding from both the Yukon Supreme Court and the Court of Appeal is really, really important, because what it says is that proponents working in parts of this territory, certainly in Na-Cho territory, where land use plans are not yet in place, but are, as is currently the case with FNNND, are being proposed and are being pursued. Projects being approved without First Nation support while that planning process is underway may well be projects that are approved in a way that is inconsistent with the treaty and inconsistent with the honor of the Crown. And I think we all know what could very likely happen if those projects and the authorizations for them are challenged. So that was sort of the core finding and the core holding of the Court of Appeal and the Supreme Court, the Yukon Supreme Court, that fully affirmed the decision of Chief Justice Duncan, and also noted, and I think this is important because I only sort of flagged this, ironically, this morning when I was rereading the case. They also note that one of the reasons to negotiate between public government and the First Nation around land use planning is to prevent the risk of an infringement. They acknowledge that if projects keep being authorized without a negotiated resolution to how that will happen, then there is a significant risk, not their words, but there is at least a risk that the approval of projects and the failure to live up to the promise of land use planning will be a treaty infringement. Not just a breach of the duty to consult, but an infringement of the treaty, right? And we've seen that happen, cases like the Nyäk case from northern British Columbia, where the ability to develop oil and gas in the territory of Blueberry First Nation was essentially stopped because the cumulative effects of development, which had occurred without support and without a planning process in place, rose to the level that the treaty itself was being infringed. And I think that's a really important holding, and I had not fully internalized it again until this morning. I'm on Eastern time, so it was about 4:30 in the morning, and I was rereading the case. And I think that really goes to show that the court gets how big a deal this really is, to allow this status quo of continued developmental authorization in the absence of a land use planning process. And Sarah's at the back holding up clocks, which I think are her way of saying I should talk faster. So I will very quickly touch on what we call the Michelle Creek case. I think probably the better metaphor is Government of Yukon and Silver 47 Minerals v. Canada, Na-Cho, Tronjek, and Yesib. And I think the caption of the case gives you a pretty good understanding of the dynamics of the case. And this was a judicial review, and this one was a first for me. This was a judicial review brought by Yukon government against Yesib. And the issue here was that now we're in a part of NND territory where there is a land use plan in the Peel. Land use plan that's gone all the way to the Supreme Court of Canada. One of the few land use plans in the Yukon. And there's a proponent in the Peel called Silver 47, who maybe is a bit more of the villain in this story than Metallic Minerals was in the earlier story. And they want to move forward with a project in the Peel. And they're going through the development assessment process at Yesib. And Yesib reviews the project, reviews what the Peel plan requires, and writes the proponent and says, under the terms of the Peel plan, before you can be authorized to begin exploration work, you need to collect baseline data. And the proponent writes back and says, we'll collect the baseline data while we're doing our exploration project. Yesib writes back and says, yeah, no, that's not what we said. We said you need to collect baseline data in order to comply with the Peel plan before you start exploring. Proponent writes back, yeah, no, we're going to do it while we're exploring. This correspondence went back and forth for a while. Both positions, well, I don't know the Yesib position. Yesib's questions remained consistent. How are you going to fulfill the obligation of the Peel plan to collect baseline data before you explore? Proponent kept writing back, we're not, we're going to explore and collect what we do. So Yesib issued a do not proceed recommendation on the project. They're not living up to the terms of the Peel plan. It's not in conformity with the Peel plan. Project shouldn't go forward. So Yukon government, which has a tendency to approve every project that gets an approval from Yesib, took a much more assertive approach here in receipt of this do not proceed. And while it was open to Yukon government to allow the project to proceed anyway, they could have just rejected Yesib's recommendation under the statute. They instead sued Yesib. They sued Yesib saying the decision was unreasonable, sued Yesib saying it's not their job to determine plan conformity, it's the job of the Planning Commission, even though there is no Planning Commission in the Peel, so I guess it's the job of nobody, but better it be nobody's job than Yesib's job. They sued Yesib and sought to quash their decision. The First Nation of Na-Cho, TH were both part of the case opposing this effort to quash Yesib's decision. As was Canada, because as folks are probably aware, Yesib is a creature of Yesa, which is federal statute. So Yesib is a federal board, and it's sort of generally the role of the Attorney General of Canada to defend federal boards in court, because the boards are not supposed to have positions on whether or not they themselves did the right thing. There's administrative law rules around that. And so the AG steps up to do that, and Yesib was also there in a more limited capacity. And before Sarah holds up another clock at me, I'm going to talk quickly and basically say Yukon government's challenge to Yesib's decision was rejected. There was a lot of arguments made about how this sort of thing should be done in the future and the implications of land use planning processes and how conformity with land use plans should be considered. And all of that argument was for naught because the court ultimately concluded you can't sue Yesib for a recommendation. What are you talking about? This isn't a decision. This is a recommendation. And weirdly, the party suing the person who made the or the group, the board that made the recommendation, is the one that gets to decide if it's going to accept the recommendation. So ultimately, yeah, this is not an available thing for Yukon government to do. You can't be unhappy with Yesib's recommendation and sue them. You have to make a decision. I think Yukon government didn't make a decision because they didn't want to accept the decision, and they knew if they rejected, they were going to get sued. And so that was, again, that's speculation. I don't know. But ultimately, the court's conclusion was to avoid the sort of broader legal questions about what role land use planning decisions take, or land use plan terms should have when making recommendations, and stuck to sort of the more more fundamental administrative law principles. And I think we wanted to end on this case really just to say, it seems that the lessons have not been learned. It seems that the need to uphold treaty promises around land use planning and around the participation of First Nations in lands management as paramount constitutional obligations has not been learned, since pretty much the first thing that Yukon government did after losing in the metallic minerals case was to decide it made sense to sue YESIB, which was trying to ensure the terms of a land use plan and appeal were upheld. And you can draw your own conclusions about the decision-making process that led there, but I can say, as NND's lawyer, and I suspect Chief would agree with me, it did not leave anyone with the sense, oh great, now we're on a path that'll send us in the right direction, collaboratively rooted in that kind of purposive and intentional affirmative treaty implementation and fulfillment of the honor of the Crown. So I'm going to stop there. I could go for hours, but I'm going to stop there. And I think we're going to briefly do questions, and then I'm going to hand it off to Tasha and the reps from NND to talk about NND's mining policy.
Thank you, Nuri and Tasha, for that really powerful presentation. We're going to start with questions in the room. I've kind of got a roving mic, so we're going to need some teamwork to pass it around. I'm just going to ask that you state your name for the record, because we are recording this session. So did anyone in the room have a question?
We said everything that could be said.
Yeah, there's lots of processing happening. Okay, we do have a couple in the chat. I will preface this with our legal team might not be able to answer everything. So, yeah. A question to the Vic Gold disaster. According to the UFA Chapter 14.12, First Nations have a right to be compensated if the water quality, quantity, and rate of flow in the territory is substantially altered. Will this happen in the case of Victoria Gold, and how will compensation be determined?
Yeah, I don't think we can answer that. I mean, I think we can say certainly that's true. Protection of water is an essential, central right of the final agreements. And the preservation of the quality, quantity, and rate of flow of the waters running through or adjacent to NND settlement land is a central promise of the treaty. I think we can all agree that dumping hundreds of thousands of cubic meters of cyanide contaminated water into the waters of NND traditional territory probably didn't maintain the quality, quantity, and rate of flow of those waters in the way that they had been previously. And there was nothing in Vic Gold's water license that allowed them to have their heat facility fall off a cliff and end up in Haggard Creek. So I think certainly you would be hard pressed to find a way in which what happened to Victoria Gold was consistent with the principles and promises and express terms of Chapter 14. What that will mean in the future, I don't think we know. I think it's fair to say that the NND team for the last 16 months has been fully engaged in trying to respond to this disaster. I don't think the focus of anybody has been on compensation. I don't think the focus of anybody has been on, you know, who do we go after here? I think the focus has been on what can we do to prevent this disaster from getting worse. And we heard so much from Bill and Cord, Chief and Farzad and others yesterday about that. So I think up till now, I think it's fair to say that NND's priority is disaster response, protection of its lands and waters and wildlife and the way of life of its people, rather than focusing on, you know, what might come next.
Next question from the online folks. If Yukon's free entry claim staking violates the Crown's duty to consult as part of treaty implementation, then shouldn't it be removed in the new mineral legislation?
Yes. Easy answer. I think there are many changes that are required through new mineral legislation. I think the free entry staking system is simply the tip of that iceberg. We already have the Ross River case talking about the need for meaningful consultation before claims are staked. And certainly YG introduced the Class 1 notification system in response to that. But I think if you talk to any lands department, NND, Little Salmon, any First Nation in the Yukon, you'll know that the Class 1 notification system allows for, what is it, a 50-word response on a proposed Class 1 submission? Millie, 50 words? 1,000, okay, 1,000 words. I don't think that qualifies as meaningful consultation. And I think the fact that every Class 1 that has been proposed in NND traditional territory has been authorized. Millie, care to correct me if I'm wrong, but yes. So I think that suggests that the consultation around staking is ineffectual and meaningless. And I think that's one of the many issues that needs to be resolved through co-developed new mineral legislation between First Nations and public government. And there are unfortunately many others as well.
Perfect. That's all we have in the chat online so far. I'm going to throw it to the room. All right. Okay. We're going, next up we have an overview of the FNNND mining policy, but we're going to take a short break first. Probably 5 or so minutes if folks want to stretch their legs. And so folks online, you can come and we'll be back online in about 5-10 minutes. Thank you so much. With the second half of this morning's presentation. So this segues really well into an overview of FNNND's mining policy that, as Chief Hope shared yesterday, the day of the Eagle Gold Mine disaster, Chief and Council was slated to approve the mining policy that morning. So it was very poetic timing for this to get going. This part is going to be about an hour, so a little bit shorter than the first session, and we are going to have another Q&A as well. So folks online, please feel free to drop your questions in the chat. Go again, and without further ado, we'll take it away to Tasha.
Great, thank you so much, Sarah. And I think just to sort of segue from the first part of the presentation into the mining policy, I think it's really helpful to consider the mining policy as FNNND's answer to the lack of public government's responsible management of resources in the FNNND traditional territory. So I do wish I had Bill Slater's fail stamp with me today. But if you look at some of the cases we talked about in the first part of the presentation, the White River case, in which the Class 3 exploration project proposed by Tarsus, that authorization was quashed because of failures to consult properly. The authorization for BMC's Kudsakaya project on Ross River lands, the authorization for that project was quashed. Also because of failures in consultation. And then the metallic minerals case, which Nuri went through, again, the authorization was quashed because, spoiler alert, failures in consultation. So I think there's a lot of failures here, and I think FNNND's approach to avoiding those failures in the future is the mining policy. So the mining policy reflects FNNND's vision for how mineral resources can be explored and developed on the FNNND traditional territory in a way that is respectful of FNNND's rights, respectful of FNNND's interest, respectful of FNNND's treaty. So I'll pause there and turn it to Chief.
Thank you. I guess I'm going to need the clicker. Thank you. So we're going to go down the line and share this presentation. So the agenda that we're going to go through today is the introduction of the First Nation Na-Cho, then the context of the mining policy, principles and procedures of the policy, implementation of the policy, and then we'll do the questions and answers. Oh, did it go? back. The First Nation of Na-Cho is a self-governing nation. In the Northern Shoshone language, Na-Cho means people from where the big waters converge. The First Nation of Na-Cho has depended on, learned from, and stewarded our traditional territory since time immemorial. And our inherent right to self-governance has been recognized through modern treaties with government of Yukon and Canada. Those were signed off in 1993. The First Nation of Na-Cho it covers 160,000 kilometers squared. Approximately 130 of those kilometers is in the Yukon, and the rest is overlapped into NWT. Within the Yukon, our traditional territory stretches from Fort McPherson in the north to South McMillan River and the Pelly River in the south. And from the Dempster Highway in the west all the way to the border of the NWT. And of course, just as I said, beyond. Our traditional territory is a focus, it's a focal point of Yukon mineral development, as we know. There are 82,000 quartz and placer claims in our traditional territory, which accounts to about 43% of all quartz claims in the Yukon, and they're all our traditional territory. We have been uniquely impacted by mining industry, and it's been a clear treaty entitlements to advance resource governance within our traditional territory in a way that honors our rights, our practices, and our values. This is especially true through our Chapter 11 processes, for which much of our traditional territory we're still waiting for. As we've talked about, the disaster happened on June 24th and released 4 million tons of cyanide. And as we said, this was the day that we adopted this mining policy and signed it off. We're still grieving, yet working hard on mitigating all the impacts of that disaster and thinking about our future generations. The policy and Eagle disaster will help guide our engagement with mining proponents moving forward, recognizing that there's still things that need to be amended through the policy that we didn't consider because it was past the day of the failure and doesn't address the challenges that we have been experiencing since. So I'll pass it over to Millie now. Oh, I went too far. One more. There we go.
Thank you. Okay. Land use planning and mining. NND has recently begun a Chapter 11 land use planning process with Yukon government. Yukon courts have recognized that authorizing development during the dependency of land use planning may impact the eventual planning process and NND's treaty rights. NND issued a notice to industry and investors that our Chapter 11 land use planning has begun and proponents must engage NND in accordance with our mining policy. So I'm just going to go through the mining policy. I'll have to do that too. So the mining policy. For NND to consider a proposed project, the proponent must confirm in writing that the project will only proceed with the First Nations consent. NND supports sustainable development in NND's traditional territory when it is found in NND's ancient principles of reciprocity, respect of NND's rights and interest, and consist with NND's traditional use and ways of living in NND's traditional territory. The mining policy sets a clear terms to ensure this balance is achieved and maintained while accommodating development. The policy creates a potential pathway to obtain NND's consent and support for mining activity. So the overview of the mining policy, the purpose and scope of application, guiding principles, procedure for engagement with proponents, and the framework for NND's decision-making. So the purpose, communicate NND's approach to mining, provide clarity and transparency to proponents through all project stages, ensure proponents understand NND's principles and procedures for mining activity, and reflect best industry practices. The policy applies to all proponents and all existing or new mineral activity in NND's traditional territory, including staking, exploration, and mining development. The policy is a living document and may be revised by NND at any time. Guiding principles. The 4 principles of Dunkey are way, respect, caring, sharing, and teaching. NND's rights and obligation to govern our traditional territory, inherent and annihilation right to govern traditional territory since time immemorial. UNDRIP requirements for free, prior, and informed consent before projects undertaken on an NND's traditional territory. Constitutionally protected Aboriginal rights, including those enshrined in the NND's final agreement. The policy and NND rights. The policy upholds NND's Aboriginal and treaty rights under Section 35 of the Constitution Act. The rights protected by UNDRIP and right to advocate before regulatory courts or Crown bodies regarding any Aboriginal treaty or inherent right of NND or any fiduciary or other duty owned by Crown to NND First Nation. Oh, okay. The core principles for mining activity. NND will exercise our rights to ensure all mining activity in NND's traditional territory is consistent with NND's core principles. Protecting and advancing NND's Aboriginal and treaty rights, UNDRIP and inherent rights, titled interests and ways of living. Ensure sustainable development of NND's traditional territory with a holistic view of cumulative effects and socio-culture and socioeconomic impacts. Advance NND's self-governance and self-determination, including by providing meaningful economic benefits to NND and its people. NND will consider working with proponents who seek a relationship with NND based on those core principles. I'll now pass it on to Lauren.
So the foundational aspects for the mineral activity decisions are early engagement, formal agreements, foundation for actions, traditional knowledge, and financial support. NND expects proponents to engage prior to submitting any proposals to assessment or regulatory bodies. Relationships with proponents will be framed by one or more written agreements, which can include MOUs. NND's actions, perspectives, and decisions will be based on the best available traditional knowledge, scientific information, and expert opinion. That means traditional knowledge stands out, though. It is first and foremost. Proponents will be transparent, accountable, and forthcoming. Sharing and use of traditional knowledge shall be subject to a written agreement and consistent with the principles of ownership, control, access, and possession, or the OCAP principles. And financial support. Proponents will generally be required to support NND's costs for sharing traditional knowledge, overall engagement, and consultation and participation in the regulatory process. So step 1 is the Memorandum of Understanding. Proponents submit written requests for NND's consent and support to Lands and Resources Department. The policy specifies information to be included in request for consent and support, roughly comparable to a typical project proposal. It includes detail about the type of mineral activity, baseline sampling or studies, and types of anticipated impacts. Requests must include confirmation that the proposed activity will not move forward without NND's consent. Lands will invite proponents to enter an MOU with NND, setting out fundamental aspects of relationship. Lands shall respond within 20 days to confirm receipt of signed MOU and provide next steps and provide further information. We'll adhere to those 20 days if we can. We try to respond to these things in a timely manner as much as we can. Step 2, lands assessment of proposed mineral activity. We have receipt, further information, and criteria. Upon receipt of the signed MOU, lands will begin the assessment, and it is a full and fair consideration of the information received from the proponent. Further information, lands may ask if we need further information to get more clarity on certain aspects of the project. Criteria, the policy specifies criteria lands will consider in completing the assessment. This includes potential impacts on NND's traditional territory, including the lands, waters, and beyond human relationships, combined with cumulative impacts of development. Potential impacts on the exercise of NND's Aboriginal and treaty rights and ways of living, and whether the proposed activity is consistent with NND's core principles of caring, sharing, teaching, and most importantly, respect. Step 3, the land's determination on proposed mineral activity, consent and support, do not proceed, and council review. Following the assessment, lands will determine whether NND could give consent and support to the proposed activity based on consistency with the core principles. Again, those core principles are caring, sharing, teaching, and most importantly, respect, and the relevant guidance for land and resource management in NND's traditional territory. Lands may determine that the proposed activity is inconsistent with the core principles. Again, those core principles are caring, sharing, teaching, and most importantly, respect. And NND's approach to mineral activity, and issue a do not proceed notice. Where the proponent complies with the do not proceed notice, NND may issue a press release in support of the proponent. Failure to comply may be met with legal action. Lands may also refer the proposed activity to council for the review. And that would include, potential next steps is council review. The proposed mineral activity to council will provide information to facilitate review and consideration. Council may determine that an impact benefits agreement is required. Any agreement shall advance NND's core principles. Again, those core principles are caring, sharing, and most importantly, teaching and respect. The policy contains standard agreement provisions and potential areas for negotiation. A proponent with an exploration agreement will be subject to a new assessment if it seeks development minerals. And following conclusion of any agreement, NND may review and ratify it. So this is kind of an outline of the steps that I just went over. So you would have request for consent and support, then NND would enter into an MOU with the proponent, then there would be an assessment, and lands would determine next steps, and the potential council review and execution of agreement. So YESIB assessment, YESIB applications should only proceed with NND's consent and support. NND will determine the scope and nature of its participation in YESIB or regulatory proceedings. NND shall seek to ensure its participation in YESIB assessments is adequately funded by the proponent or the Crown. Reclamation and ecological restoration. This is something that's very important to NND and really needs to be developed more with mines, and we're hoping to see that move forward. So proponents are expected to carry out state-of-the-art progressive reclamation and ecological restoration through detailed reclamation and restoration plans, which lands will review and approve. The policy contains specific requirements for reclamation and restoration plans, including objectives, baseline data, methods and timelines, measurable indicators of progress and completion, annual reporting, and responsibilities for legacy infrastructure and disturbances. Reclamation and restoration plans must seek the highest level of ecosystem recovery attainable. And they also must integrate community and NND guidance in articulating objectives and create prioritized opportunities for NND businesses. Commitment to NND in the mining policy comes with clear benefits for proponents. I think we've established that with this overview. It ensures a smoother, more defined engagement process. It's less combative assessment and regulatory process. It works in partnership towards a mutually beneficial understanding of the proposed activity, and it obtains clear social license for the proposed project. Developing an MOU to guide NND's engagement with proponents creates a mutually beneficial and productive working relationship. Commitments to consent-based engagement, financial support for NND's engagement with proponents, because it doesn't come, this whole process isn't cheap, and other matters that NND may identify. Na-Cho.
The team was much quicker on that one. So we're gonna open it up in person if we have any questions before we start online. Okay. State your name for the record too, please.
Yeah, Chief Stephen Charlie for Liard First Nation. Listening to all the, discussion here about, rights title, settled areas, unsettled areas, and a lot of the times it goes back to just clarification, certainty, and approvals. And I haven't seen anything put forward yet by government that will actually address the situation. The First Nations that have claims have entrenched processes within Canada and constitutionally protected, and have a trilateral relationship with the territorial and federal government themselves. I do see a way around this. And it's basically, I really believe that just about the entire process has to be revamped. Environmental assessment, industry and government may look at this policy put forward and say there's too many things to agree upon that empower the First Nation. But I agree with a lot of it, and if the marriage can be fixed, as someone mentioned this, it's always better to see the marriage succeed, unless there's irreparable differences. Anyways, but I have this, from looking from afar, that the courts are finding with the First Nations. Why? Because the process is broken, and government is trying every way to move through the process, and they're finding that whatever arguments that they're drafting up and putting forward, it's not working. So this brings uncertainty for industry. The CASCA, we haven't signed an agreement because our rights and title and interests are intact to all our territory. And the reason that we haven't signed is because our elders go with the principles of Na-Cho and what they're put forward. Respect, caring, sharing. These things are just paramount And until those aspects are incorporated into land use planning, environmental assessment, working with industry, we need industry. We need work, we need to develop wealth. It's been far too long that the Kaska have been left out, hamstringed and basically starved out of, you know, but we, as the largest First Nation in the Yukon, have decided to go at a different route. It's not that we're against development. It just can't infringe upon our relationship with the land, the water, its animals, the plants, and our relationship between each other. So, you know, if this is done properly, as described in this policy here, there's give and take negotiations and proposing projects that are not going to be failed. If you just look at the Kaska territories that rich like Na-Cho and Nyäk done in resources, we haven't ceded, surrendered any of those resources. Our rights, entitled, and interests are paramount to the colonial governance that has established their perceived rights entitled to our resources. We need to work together to develop something. You know, one day Yesub says, you know, is you know, making a decision that sounds right, and the next time they're making a decision that is contrary to what the First Nation feels as proper. All this uncertainty it's not good for business. It's not good for the Yukon people or our territory or the First Nations. But if we establish, you know, a process in which all this is met beforehand, and the First Nations at the table with free, prior, informed consent, you know, there's not this long, huge consultation process because all the work is already agreed upon, and this project is agreed to move forward. And then, you know, instead of being adversarial, is a partnership. And things will go so much smoother. You know, industry looks at, you know, shareholders, and their bottom line is profit. They want it to maximize their, you know, their growth as fast as they can, for they can go somewhere else. Well, the First Nation view of that is, whoa, whoa, whoa. Going too fast may have an accident, and we'll end up with the harmful impacts of that in another failed mine. The taxpayer has to front. So I think there's ways in which we could work together to move forward on this. And it's not all no, no, no. It's, you know, as described in the policy there, let's develop the proper processes within the mining. It may cost a little more, but then you have buy-in from the First Nation from the get-go. If you can bring harmful chemicals into our traditional territory, and that's built into your business model, well, how about build into your business model that you remove those harmful chemicals when you leave, and just build it into the model. Once the First Nation sees you're going to develop waste, produce waste, and remove waste, then, you know, you're going to have greater buy-in. And if it's done up front, you build into the cost of your project what it's going to cost X, you know, and if it's not feasible, then it's identified right at the beginning. Instead of making a huge profit, not living up to the responsibility of the mess you produced, and leaving us with another failed mine in our territories. And the failed mines in our territory for the Kaska, we have Faro, And the Casca never benefited from that once, anything. Even in the remediation, another large company is taking over that, and the Casca are just getting scraps. There's no reason why we can't manage that project. We didn't create it, but it'd be really nice if we could benefit from the cleanup of that. And a couple more things. We're living beside a country that doesn't see us. That's going to cause great troubles. And internally, those pressures on Canada, the Crown, are showing up in legislation that will fast track development in our territories. And, everyone, government is stating that they will live up to their obligations of consultation and engagement, and those processes won't change, but we're going to fast track things. Well, they haven't done the proper processes in the lengthy process. How are they going to meet the fast track? So it goes back to, again, of establishing correct policies and processes in environmental assessment and engagement and consultation with the First Nation up front. So you save money in the long run. And, you have benefits agreements established. Benefit agreements should not be able to be transferred from one proponent to another, because then that benefits agreement is then touted around the world that we have an agreement with this First Nation that's 20 years, 25 years old, and monies are secured on those, and then all of a sudden those benefit agreements that are dated are challenged in court, and so it just comes back to bite the industry and the shareholders and in their pocketbook again, because there's shortfalls in those processes. But I really thank Chief Hope and Na-Cho for and their perspective. And it's very unfortunate to see from Nyäk First Nation, a signed First Nation in the Yukon, have to do these things to actually be heard, to be seen, and from a perspective of looking from an unsigned First Nation, I'm going, holy, this is not what these agreements were intended to do. And it's just mind blowing for me to see this, and I'm here to support Na-Cho Nyäk and what they're doing, and we continue to move forward with the limited resources we have. But the bottom line is, the elders always say, and this is respect, we take care of the land and the land will take care of us. And that's paramount in anything that we look at. And thank you for listening to me. I know there's different opinions in this room about what I've said, and maybe different ways of addressing the situation, but that's good. Let's put it on the table and let's deal with it, and let's come up with something that we can all agree upon, that it's not to say that it's etched in stone, whatever we agree upon, but we can have formulas for amending these processes as they move along. Maybe it's too strong one way and it stifles, but right now the process now is stifling First Nations, and it's hurting the environment, I believe, and it's hurting industry. So I think we could work together. We got a new government now. They want to move things forward. Well, let's work on them. And industry, take this back to your people and say, you know what, Chief Charlie and Chief Hope are speaking the same language, and that you know, it doesn't. They're not saying they can't work together. We just need to change the process. Thank you.
Na-Cho, Chief. If you want to just state your name as well.
Lois Murcroft, University of Toronto student. I have a question related to your mining policy and the reclamation and ecological restoration. And you made the point that you need to see a measure of the cumulative effects of resource extraction in your territories. This is a decades and generations long issue for Yukon residents and for Yukon First Nations. And I wonder what your assessment is of public governments, Yukon government and Canada, in measuring the cumulative effects of resource extraction on your lands. I know your citizens will see those effects when they're on the land, but what is your take on what government is doing and could do? And also, have you approached mining corporations or the Yukon Chamber of Mines or nationally the Prospectors and Developers Association of Canada for support in reconciling those cumulative effects of mining? Thank you.
Interestingly enough, we do have a clause within YESA to request cumulative effects studies in section 117. And we have actually engaged or tried to engage in that. And I'll let Lauren finish that because that's her focus for Na-Cho is that work. Thanks.
I think what ends up happening is the responsibility for communal effects gets kind of volleyed between the different agencies in the regulatory process, and no one's really taking a full cumulative look at cumulative effects, and it just kind of gets pushed under the rug as of right now. I think the idea in the long run is that eventually land use planning will happen, and hopefully the commissions will still be in effect after the land use planning is starting to be implemented. And then these commissions can start really looking at the cumulative effects. But as of right now, there isn't someone who you can say in the current development assessment process that you can point the finger at and say they're responsible for looking at cumulative effects. And NND, in all of its submissions to YESUB and all of its submissions to YG and the Yukon Water Board, do make a point of stating this project is not a standalone project. It has many projects around it that are going to cumulatively impact the environment and the people. And unfortunately, we just don't have a response on that currently.
Anyone else in the room? No? Okay, we have a couple online. So question online is how have companies responded to this policy since it's been enacted?
We are actually quite happy. There are several companies that this is all expected for them, and just as people have mentioned, all they're looking for is certainty. They want to know where they can go, what they can do, how long they can be there, who they have to talk to, and they just want a simplified process. We have, and they have been very patient as well. Recognizing that we're still in the middle of the Eagle crisis. So they've been patient and willing. So we are very, it's a good thing forward. And just as Lauren said, those will get more, I guess, divvied up once the processes are applied for the do not proceeds and stuff, so we'll be able to manage it better on the landscape.
The last question I have here on the chat is the overview referred to needing to work with YG Mines to further develop certain aspects of the policy. I'm curious about the responses NND has had to date from YG EMR and YG political leadership. I'm curious about the responses NND has had to date from YG Energy Mines and Resources and YG political leadership.
Regarding the mining policy?
Yes.
I don't think,
We've had none.
yeah.
Into the microphone, Chief.
We've had none. We did present the mining policy last year at the Geoscience, followed up by Roundup. It's been out. We've been passing it out to all the proponents, to anyone who asked. They haven't asked.
Anything else? Okay, we have recorded this session, and so we will be publishing this recording online. Stay tuned to our social media channels and website for the links for that. But huge Na-Cho to everyone who has joined us online and in person. This has been another really valuable conversation over the last couple of days, and we're really grateful for everyone that joined us here today. Na-.